Well, hello, everybody. It's 9:30. I think we should probably go ahead and get started. Welcome to the August webinar here at Weintraub Tobin. This webinar, They Manage Your Workplace and They Can Get You Sued, is all about how important it is that companies train their managers and supervisors, not necessarily to become HR experts or employment law experts, but really to give them some sense of what the employer's obligations are with respect to employees in the workplace and what certain rights and obligations employees have in the workplace. So we're going to get started here in a minute. Let me just do a couple of housekeeping announcements. As we always tell you, we have a lot of material to cover today, so we'll be moving through the slides fairly quickly so we can give you as much information as possible. An e-blast did go out shortly before the webinar with a copy of the presentation with some information on how to request HRCI credit or MCLE credit for any lawyers on the line. If you registered late, you might not have received that e-blast, but there will be a second e-blast that goes out after the webinar, which will also contain a copy of the PowerPoint materials and that information for MCLE or HRCI credit. Today, we're not going to use the chat or the raised hand functions just because we don't have time to really monitor and address those as we go. But if you have a question, go ahead and post it in the Q&A section on that Q&A button at the bottom of your screen. And if time permits, when we're done today, we'll try to address some of those questions for you. So today you're going to have me and my partner here in the Labor and Employment Department, Lukas Clary, present these materials to you. I'm just going to do a brief introduction. Lukas is there on the screen too, you can see him. And then I'll turn it over to Lukas. Okay, so we'll go ahead and get started. I just want to let you know why we think this training is important. If I can make my screen move. We always have a little bit of delay here. Hold on. Okay, so why do we train supervisors? If you look at the employment cases filed in federal and state court, the unfortunate thing that you'll see when we synthesize these cases is often the lawsuit against the employer, against the company, is based on what a supervisor did or did not do in relation to the employee who's brought the claim. And that's not because supervisors are bad people. It's not because they're out to try and get the employer sued. It's really because they just don't know. They have not been trained on what the employer's obligations are in relation to their employees. And, you know, the fundamental starting point that we all have to keep in mind is that an employer usually is an entity, and an entity can only act through its managing agents. Those managing agents are its managers and supervisors. And so what they do or what they fail to do can be imputed to the employer and put the employer at risk of liability. So that's why it's important to train them, not just on mandatory training, but really an introduction to various subjects under employment law compliance. And lawsuits are expensive. We've given you some statistics here. They're pretty scary. 30% of all civil lawsuits are actually employment related employment lawsuits, and plaintiffs have a pretty good track record. 41% of the cases are successful for them, with an average award of $450,000. So you can imagine those that are much larger than this average. And then punitive damages, those often come into play. You know, those are to punish the wrongdoer or deter others from engaging in similar conduct. And those often can go up, we see when we synthesize the cases, when a supervisor merely made precipitous decisions, ignored employer policy or the law. So well-trained supervisors are really important, and they can help reduce employer liability. So what are we going to cover? This really is kind of a grab bag. We're not going to train you necessarily on the substance of all of these particular subject matters related to the employment relationship in the workplace. But we're going to point out that these are the main areas, and within them, what are some of the things that you should be making sure your supervisors are trained on or aware of. So, you know, hiring and performance feedback all the way through discipline and termination, kind of the life cycle of the employment relationship. EEO issues like harassment, discrimination, retaliation, and abusive conduct. Training is required specifically in this area of law, but we'll talk about what is important for supervisors to know. Employee privacy rights, workplace safety obligations, wage and hour oversight. Lucas is going to talk about, you know, what are some of the key things in the wage and hour arena that supervisors kind of get wrong because they may not be aware of compliance requirements. Accommodating disabilities and leaves of absence, and then outside substantive law, really the importance of timely, kind of contemporaneous and effective documentation with respect to employment issues in the workplace, and then of course a supervisor working with HR. So with that, I'm going to turn it over to Lucas, who's going to get us started.
Thanks, Beth, and good morning, everyone. So the first thing we'll kind of jump into that where supervisors are directly involved in the employment process begins with hiring. And, you know, probably the primary aspect of their job as a supervisor is the, you know, overseeing hiring, discipline, and when necessary, terminating employees. So there are aspects of each of those steps where it's important for supervisors to have a general understanding of legal obligations and what they need to do to make sure that they're not putting the company at risk with their practices throughout each of those stages. So I'll jump first into hiring. If I can get the screen to move one sec. Here we go. So the very first place you start when you're going to hire someone is generally going to be the advertisement or posting or whatever it is that you're doing to communicate out to the general public that we have a job available that we're looking to hire. And oftentimes supervisors are involved in that process. Perhaps they're the ones actually drafting the ads, hopefully working with HR or if you have legal counsel. But to the extent that supervisors doing this, being the ones preparing the ads, they need to be aware of you know, making sure that they're not creating language or putting language in the ad that can inadvertently trigger some potential legal risks. And so what we're always talking about here are protected classes, right? Everyone's a member of a protected class or multiple protected classes as recognized by the law based on age, gender, national origin, you know, disability status, ethnicity, marital status. There are all sorts of them. And sometimes we can create language in a job posting that is not intended to run afoul of those laws, but can trigger that issue. And so you'll see some examples here on this ad. If you say it's a one-girl office, you know, you're communicating that you know, a sexual trait, a sex trait. If you say we have a 2-week training, wife can attend, you know, you're making a presumption that the person, this could be a sex issue or a marital status issue. You're making a presumption that it's not a husband that might be attending, or that you might be hiring a single person, you know. Another example, native English speaker required. Now it may be that an essential function of a job is the ability to communicate in English. There are certainly a number of jobs where that's the case. However, doesn't necessarily mean someone has to be a native English speaker, right? So you can, you know, you want to be careful with how you construe that language. You know, and you can see all of these as examples. Good physical shape. Now, there might be some essential functions of the job where someone has to have the ability to be on their feet for extended amount of time, lift a certain amount of weight throughout the job. And you can communicate those requirements in a job posting, but you want to stay clear of more general language like good physical shape that could be construed as singling out people with disability status. So kind of a fine line there, but you really want to think through these issues and what you might be communicating in a job posting. So if you, we always say a picture is worth 1,000 words, and here for today's purposes and what we're talking about, a picture can be worth an employment claim of discrimination, because sometimes it's not even the language like I just had in the last slide. Sometimes it's things that are communicated in a picture that create problems that you might not even be thinking about, and I have another slide that I'll jump right to that shows some examples of that. Now, if we were in person in a seminar, I might be asking for a show of hands and calling on some people to point out some of the things that are communicated in these pictures that might communicate some type of protected class status. But obviously we're not in that environment, so I can just, some of them are self-explanatory, some of them are a little more difficult to pick up, but you can see, military status communicated here, political affiliation, sexual orientation. These are all things where a picture could communicate something that you might not be aware you're communicating, that could lead someone to say this place is seeking a certain type of individual in a certain protected class, and I'm being excluded because I'm not in that protected class. So you want to be careful, even with pictures, how you're communicating job postings. The next step of the hiring process where things can come up, beyond the job posting, would be the actual interview itself. You bring someone in and you're interviewing them. You certainly, again, going back to some of the examples I was giving a couple slides ago, you certainly can ask all applicants, everybody, whether they can perform what you consider the essential functions of the job, either with or without some type of reasonable accommodation. So you can ask them if they are able to be on their feet, for extended periods of time, or if they have any issues with lifting a certain amount of weight. But you don't want to phrase the questions in a way that might elicit information about someone's protected class that might not otherwise be apparent. So you want to stay clear of questions like, when were you born, or do you go to church? Things like this that really have nothing to do, when you take a step back and think about it, have nothing to do with performing the essential functions of the job and what you need to learn about that person to know if they're able to do a good job. Now, sometimes in an interview, you might be just trying to feel out whether someone, whether you're going to get along with that person, whether you think this is someone I like working with. And so you might ask questions informally, almost subconsciously, that aren't necessarily targeted toward performance of the job. And when you do that, you might have some leeway to do that, certainly, but you need to constantly be mindful of these issues, these protected class issues, to make sure you're not characterizing your question in a way that elicits information about a protected class status that that you otherwise don't need to know. So that's something that supervisors who may not be versed on this, and they are quite frequently either the sole person or among the people interviewing potential hires, they might ask these questions without realizing that they could be putting the company at risk just by asking these questions, because it could turn out you interview someone and you have a legitimate business reason not to hire them. They didn't have the right experience. Another candidate was better. And you had, it wasn't for anything you learned about their protected class status in the interview, but you now opened a can of worms where the applicant can say, why was I asked about my religion? Why was I asked about whether I have kids? I feel like I was singled out because of that, and then you're in this territory where you might have to explain it, and you might have to explain it in an employment lawsuit. And we'll get into a whole number of ways where it could be problematic, but just, keep that in mind. The other part of hiring where there are some things that supervisors need to be aware of is with background checks. Certainly it's practical and understandable that you might want to look into the background a little bit of employees before you hire them. In fact, in some contexts, if you don't search someone's background, that can be a risk. So it's certainly something that is allowable and reasonable to do, but there are a lot of restrictions. There are a lot of hoops you have to jump through to make sure you're doing a background check properly. So first one I want to talk about is a criminal check. There's, we live in an era with the internet where there's so much information out there. Some people just start Googling and seeing what they can find about an applicant, or they might take the step of going through a more formal official criminal background check where they use a third party who specializes in this to gain information. Hit pause before you're doing any of that and make sure you know the rules on how you can do it, when you can do it, and what you can and can't do. The first thing I want to point out is what we call in employment law, ban the box, which means it's a term that refers to the box that you would sometimes see on an employment application that asks someone if they've ever been convicted of a crime, been arrested, anything like that. That, as of a few years ago, is illegal in California to ask. You cannot ask someone up front as part of the job application or in the interview process if they've ever been arrested or charged with a crime. What you have to do is you have to leave that aside in the beginning, conduct the interview based on just the job and their qualifications, and make a determination if this is someone you would want to hire, but for a background check. Then you extend an offer of employment contingent on successful completion of a background check. And it's only at that point in the process, once you've already extended an offer, that you can begin to ask about and look into criminal backgrounds. Once you get to that point, you still have to get their authorization to look into their criminal background. Now, that could be a condition of hiring them, that they provide that authorization. So if they don't provide it, you can choose not to hire them for that reason. But once you've extended the offer, gotten their permission to conduct a background check, then you can look into it. I recommend using an official third party, not trying to do your own research online. There's so much misinformation out there, it's not reliable. But if you use a third party, you get a report back with the criminal record, if there is one, of the applicant. And what you have to understand about these is, it's not like if there's something on there, something comes up, all of a sudden you don't have to hire them. There are two areas you have to explore before you can decide whether you can use that information to decline to hire the applicant. The first is, what is the status of that record? Is it an actual criminal conviction that is still standing? Or is it something short of that? Is it an arrest, but they were not convicted? The case was dismissed, they were found not guilty, whatever it may be. Or did they plead guilty but enter into some type of voluntary diversion program that would allow their sentence to later be dismissed or expunged or sealed? Or if it is already expunged or sealed, all of those things, you cannot use any of those records to make an adverse employment decision. You can only use a still standing conviction that hasn't, been subject to any of those things, not expunged, not sealed, not dismissed, etc. Second thing you have to consider with background checks is, even if there is a standing conviction, you cannot automatically use that as a reason not to hire someone. You have to make an individualized assessment and determine whether that conviction provides a qualified reason under the law not to hire someone. And this is something that supervisors should not be making unilateral choices on. You should be working with HR. If you can, you should be working with your legal counsel to make sure that you're making the right call here, because you have to look at various things. You have to look at the nature and gravity of the conduct. Is it somehow related to the job? Right? Is it somebody who you would be required to drive and they have a history of driving under the influence? Is someone who would be required to handle money and they have an embezzlement conviction? Someone who is supposed to work with children and they have some type of sexual predator against a minor conviction? Things like that are going to be okay reasons. You're going to also need to consider how much time has passed. Something that happened a year ago is more problematic under the legal analysis than something that happened 25 years ago, right? So you need to make a determination that because of this conviction, we cannot put this person in this job. We don't feel comfortable putting this person in this job, and it has to add up under these. It's not a subjective thing. It's under the subjective kind of analysis. It has to add up. Only after all of that can you use a criminal background check as a reason not to hire someone. And even then, you still have to provide them a copy of what you had, let them know that you're inclined to use the conviction as a reason not to hire them, give them a chance to explain it. I'm kind of giving surface level explanation here. If you are actually in this process, you really should be working with HR and legal counsel if you can, but just know for a general overview, these are the rules. Somewhat similar with consumer reports. Now, the default rule with credit checks, essentially looking into someone's financial history, the default rule is that you can't use them. And that's the case with most employment positions. Most employees, you're not even allowed to look into that. Now, there are exceptions. There are certain people that you're allowed to look into that with, people in managerial positions, certain peace officers, Department of Justice employees, and then anyone who has access to, whether it's someone who's going to be handling the money, someone who's physically handling money or running the books, things like that, or has access to real confidential company trade secrets. There are certain exceptions out there that you are allowed to look into someone's credit and financial background. But make sure before you do that, and supervisors should always work with their HR department or legal and make sure that this is someone we can look into it for. This is a position we can look into it for. And then again, get that prior authorization from the employee, give them notice and an opportunity to respond before you use anything in there to take an adverse employment action. Okay, so that's hiring. The next area where things can come up where there can be issues is with employee discipline. Now, supervisors are almost always, hopefully working with HR for the most part, but they're almost always the ones who are making decisions about whether to discipline an employee and what type of discipline to carry out. So a few things to keep in mind when you're going through this process of potentially a need to discipline an employee. First thing is effective communication is key. Now this is true of just general life skills, right? But certainly true in the supervisor environment, and that's true, by the way, with both negative and positive or even neutral feedback. Just make sure employees are all on the same page about what the expectations are so that there are no misunderstandings when they're falling short of those expectations and an employer a supervisor finds a need to discipline someone. The employee shouldn't be able to come back and say, well, I had no idea that was the expectation, or that was the rule or that was the policy. So constantly working, through that, communicating with employees is key. And the reason those misunderstandings can be problematic from a legal perspective is you might have a genuine business reason to discipline an employee, but if you never communicated with them effectively what the expectations were, and they didn't know that what they were doing was wrong, and now they're being disciplined for it, and they're gonna sometimes think this may be, or at least this is the risk, right? That this is pretext. This is not really about me not doing the job well. They don't like me because of whatever protected class status, my disability, my religion, my gender, whatever it may be, or because I engaged in some type of protected activity. I filed a workers' comp claim, or I complained about some wage issue, with the workforce. I did something that was protected activity. I made a harassment report. And now this is the real reason I'm being disciplined. So effective communication about the expectations can cut off those kind of risks. This slide is pretty self-explanatory, but we have this kind of acronym that we've created. Respect is a good way to effectively communicate. So the R is resolve conflicts early and collaboratively, right? Don't let things linger, get worse. If you're noticing something getting out of hand, the supervisor should be working with the employees that they're supervising to get that resolved before it gets out of hand. That can involve exploring options and alternatives to resolve differences and improper relationships. So a lot of times you have conflicts at work between various individuals, co-workers. As you see that developing, supervisors should be looking to figure out ways to solve those problems. Is there some type of collaborative communication we can have to get everyone on the same page and to snuff out the issue that people are having, figure out what that might be, And then supervisors need to sensitize themselves to the difference and uniqueness of others, right? Everybody has different work styles, different experiences, different levels of emotion, whatever it may be, and there can be a tendency by supervisors to take those who have different, different perspectives, different approaches, and isolate those people and tend to favor people who have a similar style to them, and that's where problems can come up. So you need to just be aware that just because this person doesn't approach things my way, it doesn't mean they're doing things the wrong way, right? Promote positive interaction. Everybody understands thank you goes a long way. Obviously, eliminate unacceptable behavior. If you're observing something, it is the supervisor's job and responsibility to cut it out. Now, obviously, try not to lose your temper or say something that could be offensive or construed by someone as offensive, even if you didn't mean offense. That's important because you don't want to risk a claim that you're creating a hostile work environment in how you react. But consider the company's needs and others' needs as well as your own. And what I mean by that is anytime a supervisor missteps with the workforce here or fails to take into account some of the things we've been talking about, could be putting the company at risk as well. So that's something that supervisors need to make sure that they are dialed in on that and considering that I'm a representative of the company. How I react to this situation impacts the company and also your own, because supervisors can face their own liability for running afoul of these legal issues we're talking about. And then obviously take responsibility for your words and actions. Just like thank you goes a long way, I'm sorry goes a long way. So if supervisors kind of try and adopt all of these terms and approaches, it will help prevent things from getting into problematic areas in the workplace. So common pitfalls where supervisors misstep in ways that can create potential legal risk, right? The first one I've already talked about, failure to communicate expectations. That's something that that can create the problem I mentioned earlier. If they don't understand the expectation, then they don't know they're doing something wrong. And then when you tell them, when you actually discipline them for doing something wrong, they're going to think you're disciplining them for some other reason that maybe is an unlawful reason. Failing to adhere to policies is a big one. So supervisors, it starts, you got to know the policies, right? So you can have this beautiful employee handbook that is totally legally compliant, that hits all of the issues you should be thinking about, that effectively communicates what the company's policies are, and it's all great. But if in practice, that's not being adhered to, if the supervisors are not following what the policies say in the handbook, that's going to be a problem, and that's going to expose the company to risk. So it starts with awareness of the policies, but then obviously adherence to those policies is critical. So make sure supervisors are up to speed on what the company's actual policies are on any aspect of the employment relationship. Next one, failing to properly document and address performance issues. Now, here's the thing. If you don't document things contemporaneously, there could be a tendency to say, look, I just want to pull you aside, let you know what happened. Now let's move forward. If you didn't document it, you're not establishing a contemporaneous record that will be your evidence down the road that you had a legitimate business reason to discipline, or ultimately if you have to terminate an employee. Now, the reason that's problematic is because if an employee ever makes a claim that they were disciplined or terminated for a unlawful reason, either because of their protected class status or because of some protected activity they engaged in, if they can make some type of initial showing that maybe that's possibly what happened, it becomes incumbent upon an employer to establish what their business reason was for the disciplinary action. And you're documenting those problems creates that evidence that you may need to rely on down the road. So it's really important that you document when you have to discipline an employee. The failure to consistently discipline. So if you punish an employee in one instance for doing something, let's say coming to work late, but another employee is also coming in work late and they're not getting disciplined, that creates problems from a legal perspective too, because if an employer is having to establish what that legitimate business reason was for a discipline decision, they're, and they say, no, we disciplined this person. I terminated this person, or I demoted this person, or I suspended this person, whatever it might be, because they were constantly late. And they say, the employee then turns around and says, yeah, but so-and-so was late just as much as me and never got disciplined. So that shows that it's not truly about being late. You're disciplining me because of my age or my disability or whatever it may be. So consistent discipline is important. And then failure to conduct pre-termination due diligence. I'll get more into due diligence in another slide or two, but it's really important before a termination decision is made that you really explore a lot of angles. I won't get too into right now because I'm about to talk about it in a minute. Okay, now in terms of best practices, supervisors should never hide the ball. This is sort of the opposite of what some of those pitfalls were, right? So address and document performance problems. Don't let them linger. Don't fail to document them. Same thing with behavioral problems. Now, there's a difference between performance and behavioral problems. Performance being they're not doing the job well. They're not meeting their quotas. They're not getting the work done, etc. The behavioral problems are more attitude, conduct related. But both of those are workplace problems. So you need to address and document each. And certainly going back to knowing and adhering to policies, that means also addressing and documenting policy violations. Being consistent and discipline of employees. Again, I just talked about why being inconsistent was a mistake. So the corollary to that is that you got to be consistent, right? And clearly explain, preferably in writing, the consequences of continued performance or behavioral problems. They should know that if this doesn't get better, here's what's going to happen. Now, that doesn't necessarily mean you have to have a formal progressive discipline policy. In fact, we recommend against that, which I'll talk about in a sec. But you should, if you stop short of a termination and you're just doing a disciplinary action that you think they can recover from and get better, you want to make sure you're letting them know what will happen if they don't. So what else should you be considering when you're disciplining an employee? Obviously the nature of the problem, the performance deficiency, or was it misconduct or policy violation? What is it we're talking about? What's at issue? What did this employee do wrong? And what are the implications of them doing that wrong? Because obviously some mistakes, some problematic behavior, some poor performance are worse than others. They're not all created equally. Some types of things, if someone gets into a physical altercation at work, say, that might be grounds for immediate termination. In fact, in most instances, it probably is. Being 5 minutes late one day because you got stuck in traffic is not the same. So you want to understand what the performance problem was or what the issue is. And does the employee have a prior record regarding the same or similar issue? Because that's going to show this is an ongoing problematic behavior versus a one-time isolated incident. That might impact how seriously we have to take this. That might also explain why you might have, remember I was talking about disciplining consistently earlier, you might have reasons to discipline two people differently for a similar issue. And it might be because one, it was a one-time isolated thing. I keep using the tardy example. One person was 5 minutes late one time. The other person is late for work 3 days a week for the last 6 months, right? Not the same thing. So do we have a prior record of this? Could it be caused by a protected classification or protected activity of the employee? This is so important. If someone is performing poorly at work, and you have reason to know, either because they told you, you're observed something, or you're just otherwise been made aware of some type of, I'm just going to use a medical issue, a disability status, that could be contributing to or causing that performance problem. Somebody is falling asleep on the job, for example, but they might have, some type of, sleep issue where they, some type of sleep apnea or something like that. You need to examine before you say, I'm going to terminate you because you're falling asleep on the job. you need to be examined. Is there something we can do to accommodate this medical issue that will correct the behavior? And that's the interactive process of figuring out a reasonable accommodation. That the details of that go beyond the scope of what we're talking about today, but consider that, examine that, and most certainly work with HR. Don't make these decisions unilaterally. Supervisors should work with HR, and if you can, work with legal counsel to make sure you've got that issue covered up. Choosing how to discipline someone. What form should the discipline take? Again, you're going to look at various things. What is company policy? So if you have a progressive disciplinary policy, where are you in that progression? Is it time for a verbal warning or a written warning or a suspension, or is it time for a termination? I'm kind of repeating some of the things I've already talked about, but how have employees been in similar situations been disciplined? Again, you want to make sure it's consistent, or there's a legitimate reason to explain the inconsistency. All of these things you're going to take into account. Do you believe this person is capable of rehabilitation? If you think they can get better, then you may choose to stop short of termination. If it's something that you don't think they can come back from, then maybe it's time to cut ties. And obviously, very important, are they placing the employer at risk because of what they're doing? If someone gets accused of harassment and you investigate and you think, yeah, they are creating a hostile work environment for the female employees or whatever it may be, that's putting the company at legal risk. Those employees could sue. So that might be a reason to take a more extreme action than just a demotion or a suspension or a warning or something. All right, so you're going to take all of that into account when you're choosing how to discipline an employee. Now, progressive discipline, I've kind of talked about here and there. That means you start with something light and it progressively gets something more serious. Ultimately, the final step would be termination. You can certainly have an approach of moving up and down this ladder, starting with a verbal warning and then going on to a written warning or suspension. But I recommend against a formal discipline policy that requires you to go through these steps. The reason is all of your employees, well, not all of your employees, but most of your employees are at will, right? You can end that employment relationship at any time for any lawful reason. Some courts have construed progressive discipline policies as offering something more than that at will employment. Before you can decide to terminate someone for poor performance, did you first give them a verbal warning, then you gave them a written warning, then you suspended them? Did you go through those steps, maybe a performance improvement plan as part of the process? If you have a policy that says this is what we do, and then you might have to follow that verse, even if you think some initial thing is serious enough to warrant something more serious like a demotion, transfer, or termination. So an informal approach that says, yeah, we do this. Sometimes we do verbal warnings, and if it gets worse, we do written warnings, and if it gets worse, we do suspension. But we reserve the right at any time to bypass any of those steps or to make a determination that something is serious enough to warrant termination. We can treat each situation uniquely. That's important to do. Okay. Now, I mentioned earlier the due diligence before termination. There are a lot of things you want to consider before you pull the trigger on terminating an employee. So first thing is, can you articulate that objective reason for the termination? And can you better yet document? And again, so talking about what I was saying earlier, if an employee is the only time you're ever going to be defending a decision to terminate an employee is if they're challenging that decision either in court or before an administrative agency, and they're claiming that you terminated them wrongfully, unlawfully. If you're in that situation where you're defending a claim like that, you have to be able to articulate that objective, legitimate, non-discriminatory, non-retaliatory business reason for it. So can you, start there? Can you articulate it? I'm terminating this person because X, because of this pattern of behavior, because of this performance issue, because they did this, and these are legitimate reasons to terminate someone. They have nothing to do with protected class, protected activities, anything like that. Start there. If the answer to that is no, then obviously you probably shouldn't be terminating. If the answer to that is yes, then you okay, I have a legitimate reason, but there's more things you want to look into. What's the employee's tenure? Will the termination of the employee prevent the vesting of benefits? Again, if you can terminate an employee at any time for any lawful reason, but if they're getting close to, say, a retirement where they would get benefits or certain tenure, it causes benefits to kick in, you need to be careful. You need to be mindful of the argument that you're terminating this employee to prevent them from getting that. Again, all the more reason to have that legitimate business reason, right? So, but consider that. That's an area where employers get challenged sometimes. And is there even an argument that their protected status had anything to do with the decision? I used that disability, issue earlier where someone was not doing the job well or falling asleep on the job. If there's even some theoretical argument that their protected status had something to do with your decision to terminate them, you're in risky legal territory, and you need to make sure you can overcome that. And again, talk with HR and legal counsel on that. Will the termination violate any public policy? So there are all kinds of public policies out there that can be violated if someone's terminated for doing X activity. They file a workers' compensation claim. They file a harassment claim. They engaged in unionizing activities by trying to collectively bargain or gather the workforce to form a union. These are things that the law says are protected activities, and there's public policies protecting that. So if you terminate them, you could be subjecting yourself to a claim for violating that public policy. So, make sure you run down those issues. If you are thinking that through and you even remotely get into a maybe, oh, that's possible. They did file a workers' comp claim a year ago, or they did, support a harassment claim that another employee filed and they participated in the investigation. If there's anything like that that creates a maybe, you need to immediately stop and work with HR or legal counsel to make sure that you're clear on these areas. Really, termination decisions shouldn't be made unilaterally by a supervisor anyway. That you should always make sure somebody's backing you, thinking through these issues. And again, this is, I won't belabor this one. This is sort of the example I was already talking about, but if someone's disabled and that's causing an issue that might lead you to supervise, first make sure you're making an effort to see if there's a reasonable accommodation available that would fix the issue, allow them to perform the essential functions of the job. So that's the hiring, discipline and firing. And now Beth will get into some of the issues around discrimination, harassment, and retaliation.
Thank you, Lucas. Okay, I think the screen's been turned over to me. Our very capable assistant, Ramona Carrillo, who everybody on the line surely knows, is behind the scenes making sure this runs smoothly. So thanks to Ramona. So this next area obviously is an area that most companies are already aware of and are complying with training their supervisors because there's a mandate to do so in California. But there are just a couple of things we want to point out that we want to make sure supervisors understand, and you as the owner or the HR professional at the company can help to ensure that they realize these things. So let me just see if my screen will work. First off, for those of you who don't know this, there is a mandate under California law to train not just supervisors on the prevention of harassment, but also non-supervisors as well. And it applies to very, very small employers. Those with 5 or more employees are required to provide the training. 2 hours for supervisors and 1 hour for non-supervisors. And the training has to be provided within 6 months of an employee's hire, or if they assume a supervisor position through a promotion, within 6 months of that promotion. And then the training needs to be done every 2 years. When the law was changed a couple years ago, the legislation instructed the DFEH to prepare some online training that would satisfy the training obligation. They finally did that. And so employers can satisfy this training obligation through free online training through the DFEH, both for non-supervisors and supervisors. And we've given you the link here. Just a little plug for us. We also provide this training, and I believe that our attorney trainer provided training is very effective in this regard. So your supervisors probably are already going to this training, but the one thing I want you to understand so that you can make sure your supervisors understand, which they may not get in a training, depending on which training they go to, is that really the employer's risk of liability for supervisor discriminatory conduct. So there are three main EEO issues, three prohibitions under federal and state law when it comes to EEO, equal employment opportunity issues. That is, we can't have harassment in the workplace, we can't have discrimination in the workplace, and we can't have retaliation in the workplace because of someone's protected class and or protected activity. Liability for those three theories differs. So when we have a harassment issue, the employer can be liable for that harassment, and can the alleged harasser have individual liability. When it comes to discrimination, in California, only the employer is liable. Same for retaliation. There's not individual liability. So supervisors have to know that if what they do or fail to do is deemed to be discriminatory, they are placing the employer at risk of liability. They are not at risk of liability. And so how do employers ensure that discrimination doesn't happen? Well, we have to make sure supervisors know that they cannot take adverse employment action against the employees they supervise because of that employee's protected class. And we'll go over some of those protected classes in a minute, just for a refresher. Instead, employers have to ensure that when they're going to take adverse action against an employee, they should be able to articulate, and as we'll talk about later in the webinar, better yet, document through effective documentation, a legitimate reason for what they're going to do that has nothing to do with the employee's protected class. And that can be a number of things. It could be, you know, that the employee is being insubordinate, the employee's performance is deficient, the employee is violating policy, and so forth. But if we don't have that up front, and there's an inference that the employer is motivated by some illegal or improper reason, somebody's protected class, then the supervisor is putting the employer at risk of a discrimination claim. So what are the protected classes? Hopefully for everybody on the webinar, these are all familiar to you. Race, color, national origin, sometimes referred to as ancestry, religion, sex, sometimes referred to as gender. In California only under the statute, sexual orientation, sexual or gender identity, gender expression, and transgender status. Those are expressly protected under California law, not so under Title VII. However, we have seen, depending on who is in the White House and what the administration makeup is, some progression to try and get the definition of sex expanded under Title VII to include these identities. Pregnancy is a protected class, including under California law, perceived pregnancy. Age, marital status, and age, by the way, for any of us who are 40 and older and quite a few years older, we are protected. Marital status, medical condition or disability. This would also include being regarded as disabled or having a record of disability. Veteran status, and then whistleblower status as well. And we're going to talk a little bit more about that when we talk about retaliation. So this is just a refresher that, you know, if your employees, your supervisors are doing some online training to meet the mandate for training against harassment in the workplace, hopefully that training service is teaching them that harassment is not just on the basis of sex. Discrimination is not just on the basis of sex. There are lots of protected classes under federal and state law. Okay, so how does a supervisor avoid harassment? A harassment claim based on their own conduct, right? They are being taught in those training sessions, I hope, that it's illegal for them individually to engage in any kind of quid pro quo or hostile work environment harassment, meaning they can't be the alleged harasser. And they also need to know that because they are a managing agent of the employer, their conduct can result in strict liability for the employer. That means that even if the employer, the company, the president of the company, the owner of the company, had no idea that this supervisor had the propensity to engage in harassing type conduct, that company can still be held strictly liable for the supervisor's conduct. And again, this goes back to what I said at the beginning. Companies are entities usually, and they cannot, or always, and they cannot operate except through their people, through their managing agents. And so when a supervisor engages in harassing conduct, the theory is, under the law, that that is the company acting. It's imputed to the employer. So it's really important that supervisors understand that. And then, of course, they have their own individual liability if, in fact, they are found to have harassed somebody, whether it's quid pro quo or hostile work environment. Under FEHA, there is individual liability for that conduct. Okay, I just said this, harassment's not just a sex thing. We went over all those protected classes, and so it's important for supervisors to know that they can't engage in any kind of harassing conduct on the basis of any of those protected classes. And then what is their role in preventing harassment by others? Again, they are the managing agents of the employer. They are the ones that should be ensuring that the employer's policies are complied with by the employees that they supervise. So they need to properly monitor the conduct of their departments. They don't have to, hyper scrutinize, but they need to monitor the conduct and ensure that employees are in fact complying with company policy. And then they need to enforce it when employees are not complying with company policy. They should properly respond to any report or complaint of inappropriate conduct that is brought to their attention. It is not required that an employee use legal terms like, I think I'm being harassed, I think I'm being discriminated against. If an employee tells a supervisor that something is going on, or they feel it's inappropriate conduct, or they feel threatened, or they just share the details of an encounter, that triggers an obligation on the part of the supervisor to take appropriate action, right? To follow company policy and hopefully take it up the chain to HR so that the company can investigate and take appropriate remedial and, if necessary, disciplinary action. So if a complaint is made, they have to follow company policy, right? They cannot make precipitous decisions and decide that there's nothing here, right? Nothing there, nothing's going on. They also cannot promise confidentiality. Oftentimes employees will come to a supervisor and say, hey, I want to tell you what's going on, what happened last Saturday on the night shift, but I'm only going to tell you if you promise not to tell anyone and keep it confidential. A supervisor cannot promise confidentiality because the company, the employer, has an obligation to ensure it has a workplace free of harassment and discrimination. And in order to do that, it has to look into potential violations of policy and or the law. And when investigating, you can't guarantee complete confidentiality. You can do your best to protect the integrity of the investigation and keep things as confidential as possible, but it cannot be completely confidential because you may have to talk to some other people who may have relevant information. Supervisors, ideally, and I know this can't always be the case depending on the size of the company, but ideally frontline supervisors should not be the ones that are investigating and analyzing the information and making decisions about what to do when somebody brings a complaint of potential harassment in the workplace. That should be given to HR if there's an HR department, or upper management, and hopefully somebody who's been trained or has some resources to assist them in doing it properly. Because if we just let our frontline supervisors handle it, and they're not quite sure about what an employer's obligations are when investigating these kinds of things, they could make matters worse rather than better. And then supervisors obviously need to cooperate with whoever the investigator is, whether it's an internal person or if an outside investigator's been retained. They should provide any relevant information that they may have relevant to the issues being investigated. Don't keep some private, separate file of information that's not disclosed. And then obviously, they cannot retaliate against an employee who makes a good faith report to them, or any witness who participates in any investigation into the allegations. Now, that all probably sounds pretty straightforward to those of you who've either undergone your own training to prevent harassment or have been in HR for many, many years and know that this is the drill and this is what supervisors should do. But we still see it in case law time and time again, where supervisors have an employee that comes to them and tells them something is going on and they are being mistreated, or even use the word harassment. And the supervisor makes a precipitous decision, right? Just decides on his own or her own that, oh, there's nothing here. This is just a personal issue, some personality conflict or something between these two people. And so, you know, they just need to get over it. I'm not going to do anything. And so the supervisor doesn't follow policy, doesn't report it to HR. That's exactly what happened in the Grand Casino case. So nothing was done in connection with the report that the employee made, because the supervisor essentially blew the employee off. So the employee sues the company, right? The employer is at risk of liability. The employee sues. And even though that employer had a policy against harassment, there were instructions about what to do if somebody made a report of harassment. The supervisor didn't comply with it, and the company got hit with the judgment. And in this case, this is a relatively small judgment. It was $150,000 in compensatory and $200,000 in punitive damages. That's just the damages award. Don't forget also that under California law, a successful employee is also entitled to his or her attorney's fees. And so those attorney's fees often can overshadow the underlying damage award, sometimes by multiples of more than 3 or 4 or 5. So they can be very, very expensive cases simply because a supervisor decided not to follow policy. Okay, let's talk about retaliation. When we teach our trainings, our mandatory harassment prevention trainings, we also always talk about retaliation. And we do it in connection with the EEO statutes that we're focused on, because the training is about preventing harassment under Title VII and FEHA, and preventing discrimination. And so we also talk about how retaliation is unlawful under those statutes as well. But it's really important that supervisors are aware that retaliation is unlawful under many, many state and federal laws that provide some employee protection, you know, to employees, or some right. So it's not just Title VII and FEHA or the ADA with respect to disability rights, or the ADEA under federal law with respect to age discrimination in employment. But the NLRA has an anti-discrimination provision. Federal and state wage laws have an anti-retaliation provision under the FLSA and the California Labor Code. You know, employers are allowed to discuss the terms of their employment and their wages with one another. They cannot be retaliated for doing so. They have the right to raise a question or concern or complaint about their wages or the terms of their employment, and cannot be retaliated for doing so. They can't be retaliated against for raising an equal pay issue. and they can't be retaliated against for even having wage garnishments from their paycheck. Cal OSHA has an anti-retaliation provision. If an employee raises a health and safety concern, they can't be retaliated against. The big leave statutes under federal and state law, FMLA, CFRA, PDL, and USERRA, all anti-retaliation provisions as well for a exercise of their statutory leave rights. And then numerous provisions of the California Labor Code have anti-retaliation provisions in them. And we just listed a few here: employees' lawful off-duty conduct, communications about conditions of the workplace, any kind of rehab, addiction rehab treatment, and other statutory leave entitlements, which we'll talk about those leave entitlements later in the webinar today, but they all have anti-retaliation provisions so that if an employee exercises their rights under those statutes, they cannot be retaliated against. We have whistleblower protection rights in California under California Labor Code 1102.5. If somebody has a good faith belief that the company is engaging in unlawful conduct or is not complying with legal requirements and they report it, they cannot be retaliated against. And then the Workers' Compensation Act also has anti-retaliation provision in Labor Code 132A. So this usually is not presented to supervisors when they're attending harassment prevention training, because these are anti-retaliation provisions under various other laws. So it's important that HR and upper management train supervisors to at least be aware of the fact that there are protections against retaliation for many, many other employment rights under statute. What does a retaliation claim look like? We're not going to go into detail here. It's beyond the scope of this webinar, but essentially the employee has to show that they engaged in protected activity, i.e., I reported to my supervisor that I believed we had a safety hazard in the warehouse. After I reported that, 2 weeks later, I got assigned to the graveyard shift, which nobody wants to be assigned to. It's a terrible shift. And I think I got assigned to the graveyard shift because I made that report. That is an example of meeting the required elements for a prima facie case of retaliation. It does not mean that it is retaliation and that the employee will win. The employer has the opportunity, when the burden shifts, to state the legitimate reason that the employee got assigned to the graveyard shift that has nothing to do with the report of the safety hazard. But this is essentially the elements for an employee to get their foot in the courtroom door, and it's very easy to state a prima facie case for retaliation. And because of that, it's all the more important for supervisors to be able to articulate and, better yet, document the legitimate reason they're taking action towards an employee, i.e. assigning them to the graveyard shift, so that they can defend against the inference that it's retaliatory. Again, as I said before, it is employers, not supervisors, who are liable for retaliation. And so that is why it's important to make sure that supervisors have some idea as to what the employer's obligations are. And in the EEO context, it's very, very common for us to see retaliation claims tacked on to most harassment and discrimination claims brought under Title VII and FEHA. So, before I move on, I just kind of want to step aside from the slide and say, if you are training your supervisors on these topics and you get supervisors who are still kind of, I don't want to say going rogue, but I will, doing their own thing and not complying with directives and policies and the law as they have been trained under, you need to stop and think whether that person should be a supervisor or managing agent of the company, because they really do hold quite a bit of power with respect to the ability to place the employer at risk of liability, because what they do is imputed to the company. So how do we prevent retaliation? A supervisor has to know, this is very similar to discrimination, that, you know, in discrimination, I said the supervisor has to know they cannot take adverse employment action against an employee because of their protected class. In connection with retaliation, a supervisor cannot take adverse action against an employee because of the employee's protected activity. So for example, it would be very dangerous for a supervisor to give a poor performance review to an employee who filed a workers' compensation claim or just went out on 12 weeks of FMLA, if the poor performance review is because of those protected activities, right? It doesn't mean the poor performance review cannot be given, even if the employee was on workers' comp or took an FMLA leave. I'm not saying that every employee who engages in protected activity gets a, you know, get out of jail free card. That is not the message here. The message is the supervisor cannot be motivated by the protected activity when taking the action, right? So they've got to be able to articulate, document why they're taking the action, right? Why they're taking the action, and ensure that their reason, right, the answer to that why question is legitimate and has nothing to do with the employee's protected activity. For example, they're getting the poor performance review because in the quarter before they went on workers' comp or out on the leave, we have a documented performance deficiency that clearly shows they have not been meeting expectations for the last quarter. Okay, that's the kind of documentation and what I'll call evidence, if we're in a lawsuit, that is necessary to rebut a claim of retaliation. And then again, Lucas and I keep saying this, when it's possible, if you're an employer that has an HR department or upper management, even when there is a legitimate reason for taking the action against an employee, if that employee has recently engaged in protected activity, we really encourage the supervisor to work with HR when, you know, before executing on the adverse action, just because of the timing and to make sure all the ducks are in a row to reduce the inference that the supervisor is motivated by the protected activity. Okay, with that, we're going to leave EEO, harassment, discrimination, and retaliation and go into our next area of employment law that supervisors should have some knowledge of, and that is employees do have certain privacy rights in the workplace. So where do they come from? There are various laws. Under the federal Constitution, there is a privacy right against privacy invasion by state actors. That's usually the government or some private employer who has state actor status imputed to them because, for example, they're doing federal or state contracting and so forth. They could, under the case law, be considered a state actor in certain situations. But for the most part, the right to privacy protection under the federal Constitution really applies to our public sector employees. But we're in California, and under the California Constitution, there is a privacy right protection in connection with both private employment and public employment. So in California, employees who work for private companies like my firm and most of you on the line, employees do have a right to privacy in certain things. One thing in particular relevant to the workplace is the California Constitution has been interpreted as protecting the privacy of employees' personnel records and documentation. So employees have a privacy right in their personnel information under the California Constitution. There are other statutes. There's a California Consumer Privacy Act, which has been in the news over the last few years. It's continuing to be evaluated and modified. Our AG office is working on certain regulations and guidelines for the implementation and administration of this act. There's some exclusions for employment data right now, or some, I guess, certain provisions have been stayed for a period of time, but the California Consumer Privacy Act will also provide some protections to employee personal data that may be in the possession of their employer. There are other laws. There are laws protecting personal information, including pay and compensation, medical information. Various laws in California mandate that employers keep an employee's medical data and information private and secure, and actually in a separate file, separate from the personnel file, and under secured circumstances. So if it's online and electronic, you've got to have data protection and password access. If you've got hard copies, it needs to be secured under lock and key. And then there are privacy interests in employees' legal off-duty conduct as well. So what does this mean as far as what supervisors should know? Well, they should be aware that employees have those privacy protections. They should also know that a few years ago, we had a piece of legislation that created a new express statutory prohibition to make it unlawful for employers, i.e. supervisors, to ask or require an employee or applicant to provide password to social network sites. So this law under Labor Code Section 980 essentially says that an employee has privacy rights in connection with their legal, personal, social media presence, right? Their online identity and world. And we cannot ask them or require them to give us access to that, or take disciplinary action if they refuse a request to know if they're online and have a social media presence. And I'm going to tell you about a case that is rather old now, and you'll know it's old because I'll tell you that it involved a MySpace website, a MySpace social media platform. And in this case, a supervisor learned that a number of employees in his department had set up a separate private MySpace page that they had to be invited to participate in and have a password to access. And he learned through some rumblings from other employees in his department that the supervisors on that MySpace page were talking about him and his management style and complaining. And he was very curious about this. He didn't like that. He wanted to know what they were talking about. So he convinced one of the employees who was a participant in this MySpace activity to give him her password to access the page. And he used that password. He got onto the MySpace and he saw all of the online communication among the employees and what they were saying about him. And some of it, a lot of it, was not very favorable about him, and were really quite honest about critiquing his management style and complaining about the work environment. Well, that made him angry. So he terminated two of the employees, the two employees that set up that MySpace page, and a lawsuit ensued. And it turned out that the employee who gave up the password testified that she felt coerced by the supervisor to give up her password, that if she hadn't given up the password, she believed that there had been some kind of veiled underlying threats or indication by the supervisor that she would suffer some negative employment action if she didn't. So she felt coerced to give it up. And then the two that were fired said, this is a violation of our privacy. He did not have the right to get that password, and go on. And in addition, it violates the labor code, because the labor code says that we have the right to talk about, even complain about, the terms and conditions of our employment, meaning we can complain about our supervisor. And the court agreed. And the employer, not the supervisor, the employer was found liable for invasions of privacy claims and labor code violation claims. So that was quite a few years prior to the enactment of this statutory mandate, but now it's very clear by statute that employers cannot require the password or take disciplinary action against employees who do not provide it. There's another case that's also a couple years old, but is instructive in what we're talking about. Employees have a very heightened privacy right to their medical information. But interestingly enough, oftentimes the employee who has a medical condition freely discusses it in the workplace, right? And talks to employees about it sometimes, right? And so in this case, this employee had bipolar disorder, and that's a very hard medical condition for employers to accommodate, because unless medicated, oftentimes it's got very large extremes in conduct, and employees who can't keep it under control have trouble being consistent and coming to work and performing and so forth. This employee, had this bipolar, and it was known to some other employees through the own disclosure of the employee, but the supervisor assumed that because the employee talked about it, the employee who had it, that the supervisor didn't have to keep anything confidential either, and the supervisor could talk to people about it. And so the supervisor did kind of talk to everybody in the department about the employee's bipolar condition. And ultimately, when this employee was terminated for performance issues, the employee sued for a violation of privacy rights. And, the argument was, well, the supervisor talked about it, but, there was nothing in writing. All the written documentation we had with respect to the employee's medical condition was secured properly. And the court said, no, that doesn't matter. The supervisor, no matter if the employee with the medical condition is freely disclosing or discussing his or her condition, that does not give the supervisor the right to also discuss it. So once we as employers, managers and supervisors receive medical information from employees, we have to keep it confidential, regardless of whether it's being discussed by the employee. Can a supervisor or an employer legally monitor employees' activities while at work? Well, here's some good news. Yes, in certain circumstances, you can. There's been legislation introduced over the years, probably almost as long as I've been an employment lawyer, for 21 years, that has not made it out of the state legislature to put restrictions on an employer's ability to monitor their own electronic systems. So as the law currently stands, if an employer is issuing electronic communication devices, computers at work, laptops, cell phones, email systems, voicemail systems, if those are all employer issued, then the employer has the right to search or monitor those systems used by employees. The employees do not have an expectation of privacy in the use. However, we do believe it is best practice for employers to let employees know that. So if you have a policy, i.e. in your handbook, about employer issued equipment and computers or electronic devices, you should put in that policy that this is an employer issued piece of equipment. It belongs to the employer. It's being issued to the employee to use for work, and employees have no expectation of privacy, and the employer does have the right to monitor or search the systems. And then, of course, if you're going to exercise on that right, you should monitor or search consistently and have legitimate reasons. Maybe you do it across the board just as a matter of IT health, where the IT department, reviews traffic and use of the employer's system twice a year or something like that. And then if something comes up, IT turns it over to management. or you're doing it because you've got credible, legitimate information or suspicion that the system is being misused, and you can monitor it and take appropriate action. But like with anything, as Lukas has said and I've said, it's really important to articulate the legitimate reason, and in this case, kind of legitimate process in doing it, so that you can avoid having to defend an argument that you're doing it unequally and that you're motivated by some protected class or protected activity, right? You're targeting all of the minorities in your workplace and monitoring their system, or all of the older workers, or all of the women, and so forth. You want to avoid that. Okay, we've got an Attorney General opinion with respect to video surveillance. So just like you are allowed as employers to monitor the equipment that you issue for employee use, if you have employees working on site, or at an office, at a warehouse, or at some work site, you can monitor the activity of the employee. Usually the articulation is it's done for health and safety reasons and or loss prevention reasons. For example, in the retail industry or the restaurant hospitality industry, video surveillance is not uncommon because you're trying to ensure, one, that the public is engaging with your employees in a respectful manner, and you're keeping check on their health and safety, and also you're trying to ensure that they're not stealing from you. So currently the law is you can do that as long as the video surveillance is not in a private area like a restroom or a locker room, in which case employees do have an expectation of privacy in those private spaces. And so in this opinion by the Attorney General, the issue was whether videotaping of truck drivers by a third party that the employer contracted with, whether that was a violation of the law, whether that would violated Section 1051 of the Labor Code. And that section says that employees, or anybody really, cannot be photographed for the purpose of furnishing the photograph to another employer or third party. Okay, so the difference in the video surveillance I just talked about is that video surveillance that employers sometimes engage in, that's for their own purpose. They're not sending that video to some third party or some other employer per se, but it's for their own monitoring for health and safety and loss prevention. And so Labor Code Section 1051 says, look, you can't photograph people so that you're going to send that photograph to somebody else because the employee hasn't really authorized that it be provided to somebody other than their employer. And so the question here was, the employer retained a third party, a professional service provider, to videotape the truck drivers as they were out on their routes. And there was a question about whether that was a violation, a privacy issue. And the opinion said that that surveillance during their on-the-job driving did not violate Section 1051, provided the third-party surveillance company was an agent of the employer and was furnishing the data that was collected through the videotaping to the employer solely for the employer's purpose of ensuring whatever it was they wanted the videotape for. In this case, again, health and safety issues. So that's just an example of video surveillance kind of out and about. And if you're going to retain a third-party service provider to do it for you, make sure that it's very clear in your contract with them that any video surveillance data is submitted just to the employer for the employer's use. Penal Code section, California Penal Code section 6377 makes it unlawful to track or monitor a vehicle's location without the vehicle owner's consent. So this is not an employment law. This is a California Penal Code statute, but it comes up in the employment context sometimes because in some workplaces, employers want to monitor vehicle location through GPS tracking and now smartphone tracking. They do it for various reasons. Again, health and safety, efficiency, and timekeeping obligations, and so forth, mileage reimbursement, you name it. There are a number of legitimate reasons the employer can articulate why they want to do it. So the question is, does this violate the penal code if an employer does it without getting the employee's consent ahead of time? Well, we don't have a lot of case law guidance on this, but the general consensus, I think, in the employment law arena is that if you're issuing the vehicle, if the employee is driving a company issued vehicle, you can do it because they don't own the vehicle. If you're asking an employee to drive their own vehicle for work and you're still wanting to track the location of their vehicle during work hours, the best practice is you need to get consent from them to do it. And even when driving a company vehicle, while you may not need to obtain the employee's consent, I would at least give the employee notice that in fact the company does have a tracking system, GPS, or a smartphone on the business smartphone tracking the location of the vehicle. Okay, Lukas talked about this during the hiring process. Employees also have privacy rights in connection with, their credit history, their off-duty conduct, and their social interaction with individuals, and very recently with the Fair Chance Act and the Ban the Box laws, even to a certain extent, their criminal conviction history, at least as it relates to their eligibility for employment. So be careful that if you are going to pursue a credit report or consumer investigation report, which is it's like a credit report on steroids, it's credit report plus, where you get all of that information, and then you also have an agency go and maybe interview some neighbors and some other people to kind of get their opinion of the individual. It's more of a larger social consumer investigation report on the individual. If you're going to get that, a credit report or a criminal conviction information, you have to make sure you're authorized to do so under applicable law, and that if you are authorized to do so, that you follow the required steps and procedures to do it correctly. Okay. Okay, finally, I think this is the end of my section. I'll turn it back over to Lukas. Labor Code Section 432.7 also gives employees a limited privacy right in certain criminal records that have been expunged or sealed by the court. This section actually has been in the labor code for quite some time, so this is not new. There are certain exceptions, however, and that is, so even before we had to ban the box, we used to have on the employment application, have you ever been convicted of a felony? And oftentimes there would be a little disclaimer, you are not required to reveal any conviction that has been expunged, sealed, or dismissed. So that was in connection with Section 432.7. But there are some exceptions to this, as we've listed here, because there are certain situations where employers are mandated by certain regulatory mandates that govern their industry to even know about convictions that have been expunged or sealed or dismissed. So we've just listed them here on the slides for you. Okay, so now I'll turn it over to Lukas. He'll talk about workplace safety.
Thanks, Beth. Okay, moving forward, the next aspect of a supervisor's role that they are going to bear some responsibility for are making sure that the workplace stays safe. And that's not just a common sense issue. There are actual legal obligations with regard to keeping a workplace safe, largely found in the body of law that's been put out there by Cal OSHA. So OSHA, there's the federal OSHA and then the California equivalent, the Occupational Safety and Health Agency. They're the ones who are responsible for enforcing workplace safety issues and make sure businesses are keeping the workplace safe. And this is kind of an extension of what I talked about earlier with it being important that supervisors understand and adhere to all policies. Part of that also extends to workplace safety issues. You know, even if you have developed an exceptional injury and illness prevention program and have this beautiful written document, if the employers aren't following it and making sure the supervisors aren't following it and making sure the workplace is safe, you're going to have potential issues. So, you know, the nature of your industry and the specifics of what your employee are doing are going to govern some of the more detailed requirements that can be found in the labor code in terms of keeping the workplace safe. But generally speaking, you know, it's providing safety equipment, making sure that your practices and methods are you know, up to speed, you know, up to code and all of that, where employees are kept safe. There also are, and supervisors need to be aware of this because they're the ones who are going to most often become the first ones aware of workplace injuries and illnesses. There are obligations to record and report in certain circumstances injuries that occur at work. You know, now what you have to record and what you have to report, you know, it depends on factual situations. I won't spend too much time getting into it, but this is something that you need to make sure your employers are your supervisors are becoming educated on. You know, that includes workers' comp reporting and recording, and also recording and reporting to Cal OSHA directly. Now, the big thing that has been, you know, the biggest safety issue that has been at the forefront of virtually every employer over the last year and a half has been COVID-19 issues, right? And sure enough, we do now have a lot of law, a lot of guidance from Cal OSHA on how to keep the workplace safe when it pertains to COVID-19 issues specifically. So I mentioned the IIPP, the Injury and Illness Prevention Program, on the last slide. Every employer has an obligation, with some limited exceptions. Every employer has an obligation to actually have a written IIPP plan on how to keep the workplace safe. And I'll just very quickly back up to the last slide to show the link there. If you don't already have an IIPP program, a written plan, that link will be a good resource on the tool that will help you develop one. So make sure you do that. But that's going to now include specifics pertaining to COVID-19, either in the IIPP itself, or there's going to need to be a standalone COVID-19 prevention program that you must develop, a written one as well. It's going to touch upon a lot of things, including communication with employees. And what I mean by that is, you know, there's actual requirements on what you're supposed to communicate to employees, you know, in terms of how they are to maintain safe from COVID, what they are supposed to do if they, well, first, how to recognize symptoms, what they're supposed to do if they develop symptoms or become aware of COVID, you know, how to let the employer know, you know, and then obviously how to keep the workplace safe with sanitizing and masks and social distancing. This could be an entire different topic on its own where I can get into all kinds of stuff, and we don't have time to do that right now. But just be aware that the your IIPP must now have COVID-19 specific stuff in it. If you're not, if you don't have that already, then you're going to need to develop that. You can, you know, either work with your legal counsel, or you can go to that link and they'll have some information on that as well. And then obviously this is just, you know, the point I already made, that supervisors are the ones responsible for enforcing that program. So make sure that all of your supervisors are aware of the written IIPP program, that they have a copy of it, that they've read it, that they understand all the obligations under it, and that they know what to do to comply with it, because they're going to be the ones that are largely overseeing that for you. And if they don't do so and OSHA comes knocking, they're going to ask to see your IIPP. If you don't have it, or if you're out of compliance with it in what's going on around the workplace, that can result in significant penalties and civil liability to the the employer. So really important for your supervisors to understand that. Now I'll talk a bit about wage and hour issues, moving on from workplace safety. Wage and hour issues are, I would argue, from an employment attorney perspective, who's actually in the field litigating supervisor mistakes, this is the single biggest area where lack of proper training and education on obligations by supervisors gets the business in trouble, gets them sued, and they face significant liability. So this is the key, in my mind, the most key area for supervisors to make sure they've got everything right. So one of the most common areas where we see issues are with regard to time cards, whether it's whether your employees keep time in an electronic system or if some kind of paper system or time clock punching, whatever it may be. If they are non-exempt employees, meaning non-exempt from minimum wage and overtime and those requirements, then, which is most of your employees are non-exempt, then there are specific obligations for how to track time, and a supervisor needs to make sure that the employees are doing that and doing it correctly, because they're going to be the ones interacting with the employees on this issue. So what am I talking about by recording time accurately? There are various things that have to be recorded every time an employee works a shift on a time card. It's not enough to have a time card that just shows Monday 8 hours work, Tuesday 8 hours work, Wednesday 8 hours, etc. You need to show the actual start time that the employee began working on their time entry, as well as the end of the day when they finished working. But in between that, if it's a longer shift, long enough to trigger a meal break obligation, which I'll talk about in a moment, the time card must state when they began and ended each meal period. You also need to know if they missed any meal or rest breaks. So if they didn't take a break, that should be reflected in the time entry, or you might have some language on the time entry that acknowledges they did receive a break or asks them to state whether they missed a break. Time entry should reflect any split shift intervals. So and certain industries are more likely than others to have this. Hospitality would be a key one where you see this a lot. Split shifts are anytime there's a break in action during the course of a day of longer than an hour, the law will actually treat that as two different shifts. So up to an hour, you'll be talking about a meal break. But let's say someone works 9 to 1, and then they're off work for 4 hours, and they come back and work 5 to 9. That's considered a split shift, right? There are obligations potentially to pay premiums when employees work split shifts. Supervisors need to be aware of that. So there's an extra hour of pay essentially they're entitled to, unless it's a complicated formula, but unless they make enough over the minimum wage where if you divided out their money and paid them, the split shift, it still would come out to more than minimum wage. It's kind of complicated to go into today, but for the most part, you owe them an extra hour pay if they work one of these split shifts. So that's got to be reflected in the time entry. And then the total amount of hours they worked during that shift. Right? All that needs to be in there. So if supervisors are the ones examining time records, they're the ones that are, if it's a manual system, if they're the ones that are getting the filled out timesheets or the clocked entries, or if they're the ones reviewing in the electronic system when employees are clocking in and out, they need to make sure this is all in there. And I would argue it should be an active part of their job, if they're not already doing it, to monitor that and to look and to make sure that employees are hitting all of these items: start time, when did the lunch break start, when did the lunch break end time, all of that, meal breaks. And if their employees are not doing it right, if they're not writing the actual time they worked, clocked in and out, it's incumbent upon the supervisor to explain to them and correct them on what they should be doing in the face of disciplinary action if they don't do it right, because it's really important to get this wrong. Mistakes in this area can result in substantial penalties and violations to employers. Class action, what we call PAGA, representative action lawsuits that cost, depending on the size of the company, 6-7 figures, sometimes more in liability. So it's really important to get this stuff right. And that starts with the supervisors monitoring the employees and explaining it to them. So there's an example of what a proper entry would look like. Started at 8:30, took a meal break from 12:35, came back in at 1:05, ended my day at 5 o'clock, worked 8 hours total. That's a proper entry. If it just said 8 hours, improper. If it said 8:30 to 5 with a half-hour meal break and it doesn't tell you the time of the meal break, improper. So it's got to be just like you see laid out there. A couple more things. This is basically what I just said. If they don't show how much time an employee spent working on a project, then they're not going to be legal time records for wage and hour purposes. So some employees, for example, are paid on a piece rate basis, where they don't get paid necessarily by the hour. They get paid based on how many gadgets they complete, how much, how many repair jobs they do if they're an auto mechanic, how many deliveries they do if they're a truck driver. There are various ways that people can be paid on a piece rate rather than a time basis, but the law still obligates in that situation that you have a time card showing their actual hours worked. Beyond that, there's obligations sometimes to pay non-productive time for piece rate employees, meaning their rest periods or their times where they're doing something other than the production of the good or service that the piece rate goes into. If they're doing some other kind of like cleaning or something that's non-productive work, that has to be paid separately. So for all those reasons, you actually have to record their hours worked. This should be obvious common sense, but some supervisors don't know this. You can't ask them to work off the clock. No clocking out to avoid overtime and then continuing to work for 20 minutes or anything like that. That's a violation. So make sure your supervisors are aware of that. Okay, meal periods and rest periods are a huge area where employees end up suing employers claiming these were missed or not compensated properly, not provided properly. It's kind of a dense slide here, but just the gist of it is if they work more than 5 hours, they get a meal period. There's an exception where if they work between 5 and 6 hours, both sides can choose to waive it, both employee and employer. Get that in writing if you are going to do that. You're not required to get it in writing, but I advise as best practice to get it in writing. Otherwise, the obligation is at 5 hours. Even if you have one of those that waives it between 5 and 6 hours, if they go above 6, you have to give it to them. They cannot waive it. Then if employees work long enough to trigger a second meal period, meaning they work at least 10 hours, you got to give them another 30-minute meal period. These are 30-minute uninterrupted meal periods, meaning a minimum duration of 30 minutes, relieved of all duties, free to leave the premises. And if an employer doesn't provide that, then they owe an extra hour of pay, which the law has recently developed in what you have to pay them for that hour. And I'll talk about in a second, but you have to pay them an extra hour of pay. So supervisors need to be aware of this. They're the ones that are going to tell employees, either they're the ones writing schedules, which if the nature of the work allows for it, schedule a meal break at a specific time to begin within that first 5 hours, second meal period to begin within that, before the end of the 10th hour. Actually schedule it. If the nature of the job is one where it's not always practical to schedule it for an exact starting time, it's still incumbent upon the supervisor to make sure within those first 5 hours, you tell the employee it's time to take your meal break, take your 30-minute meal break, go clock out. Now, there was a big fight probably 10 years ago at this point in a restaurant case, Brinker case, that really fleshed out what the employer's obligation is with making sure employees actually take their meal periods, and where they ultimately came down, and this has been established law for a decade now, is employers don't have to actually make sure they take them. You just need to make sure that you relieve them of all duties. Tell them, you can now begin your 30-minute meal break. You don't have to do anything. You can leave the premises. If they choose to continue working beyond that, employers have met their obligation, but you have to make sure you at least relieve them of all duties and give them that opportunity. So that's something all supervisors need to know. Your supervisors need to know how to navigate this meal period area of the law, because it can cause big problems if they're out of compliance. It is okay to have lunch trainings where you basically pay someone during lunchtime, you know, we're gonna all take our lunch break, but we're not gonna call it the official lunch break, but we're gonna take a lunch break. We're gonna feed you, we're gonna have a training, we're gonna go over this stuff. That's time that they get paid for, but that's otherwise okay. However, that does not relieve an employer of the obligation to provide that unpaid, uninterrupted 30-minute break, even if they had a paid training during lunch. You still have got to either provide them that or pay them an extra hour of pay for not getting their meal break during that given shift. So those are your two options. You know, give them a separate 30-minute break or pay them an extra hour of pay. And always start the meal break within those first 5 hours. You know, if they start working at 8 o'clock and it gets to 1 o'clock and they haven't taken their meal break yet, now you're going to have a violation, even if they get one 5-10 minutes later. Here's another area where I see businesses run afoul of the law all the time. It's because supervisors don't clearly understand this issue, the on-duty meal period. So there is a thing out there under the law where employees can work sometimes in the right circumstances on duty, meaning they get their meal break, they get time to stop and eat, but they're still on duty. It could mean they're still watching the front door to see if a customer comes in. It could mean they're still needing to monitor their phone in case they get called back to do something. It could mean they just have to sit there and have a presence for security purposes. You know, there are times where an employee can be on duty, paid, taking a meal break. If both sides have a written agreement that's what they're going to do, an on-duty paid meal break where you pay them, they don't get relieved of all duties, but you pay them. During those 30 minutes, they eat, but they're still on duty. If both sides agree to that, and then the second component, this is where people get in trouble all the time, is if the nature of the job makes it impractical to actually relieve someone of all duties and let them take an off-duty meal period, that's when you can have these paid on-duty meal periods and not have a violation. So what does that mean? Where do people make mistakes on that? It means you can't have an agreement for an on-duty meal period just because we're really busy, we're slammed right now, and if someone takes a break, it's gonna, you know, disrupt operations too much. That kind of thing you really got to work around. The law is very specific that the types of situations in which an on-duty meal period can be provided only arise where the nature of the job makes it essentially impossible to relieve them of duties. So you can think of circumstances, most common place it comes up is they're the only person on duty at the time, the only person at the store, the only person in the restaurant, you know, and if they take a break and leave, the place is unsecure, you know, we'd otherwise have to lock up and close our business for a day. Situations like that are where you can have an on-duty meal period, but it's such a narrow exception. There's even a labor commissioner opinion out there where there was one manager and one other employee on, just two people on, and the supervisor had entered into an on-duty meal agreement. The argument was, we can't relieve the supervisor of all duties because then there's no manager. It's just this one employee, and if customer needs to speak about something that requires a higher level of management, this employee is not going to be able to handle it. We need to have a supervisor on at all times, so hence the on-duty meal period. The labor commissioner's opinion letter said that fact pattern is not enough. You can train your other employee to handle management responsibilities for at least 30 minutes so that the supervisor, the non-exempt supervisor, could take a meal break. So you can see it's a very narrow restriction. And if you're thinking about having someone work an on-duty paid meal period instead of an off-duty relieved of all duties 30-minute meal period, work with your legal counsel first to make sure you're on solid ground there. Okay, rest periods are the other component. So you got the 30-minute unpaid meal period, and then every employee is also entitled, if they, you know, based on the number of hours they work, to take certain rest breaks, every non-exempt employee. And that's your 10-minute on the clock paid rest break. So every 4 hours they work or major portion thereof, that same Brinker case kind of broke out the formula of what major portion thereof means. Essentially, if they work less than 3.5 hours, there's no rest break obligation. If they work between 3.5 and 6, they get 1 10-minute rest break. 6 and 10, they get 2 10-minute rest breaks during that shift. Between 10 and 14 hours, 3. So it's a 4-hour increment thereafter. These are on the clock breaks of 10 minutes where they are also relieved of all duties, just like the meal break. In some ways, it's exactly the same as the meal break, with the 2 key differences being 1, it's paid, so they don't clock out, and 2, it's only 10 minutes instead of 30, but it still needs to be relieved of all duties, uninterrupted, all of that. Where I see supervisors make mistakes that get businesses in trouble is they either combine them to the meal period. So you're entitled to a 30-minute meal period from 12 to 12:30. We're going to let you go from 12 to 12:40, and we're going to call that your 10-minute rest break too. The law frowns on that. That's not considered a separate rest break. Also, starting and ending early. Okay, just don't take your rest break today, but we know you're supposed to work till 5. Just go ahead and leave at 4:50, and that last 10 minutes, that's your rest break. Or start 10 minutes late at the beginning of the day. Law says no, the courts and labor commissioners say no, that's not sufficient. It's got to be during the shift. So they have to actually start working, take the rest break, continue working. This last bullet point, employees can be required to remain on premises during rest breaks. That's actually that's something I intended to update. The law has recently taken a turn there. Even during the rest break, they have to actually be free to leave the premises. So that's inaccurate there. It should be employees cannot be required to remain on premises during rest breaks. Some more do's and don'ts. If they do miss one, if for some reason an employee goes through a shift and either it was your choice to not give them one because you're okay with paying them the extra hour, or you just overlooked it, they got busy, you realized they didn't take it or they didn't start it in time, whatever it may be, you got to pay them that extra hour of pay, and you now have to pay it at the regular rate of pay. So this is a recent development, a court opinion that just came out last month, where we already knew we paid overtime at the regular rate of pay. We used to pay meal and rest breaks, most employers did, at just an employer's standard hourly rate. So I'll really quickly break down the difference between those two things. It only comes into play if an hourly employee also gets compensated in another way that factors into their rate of pay. So if they get a non-discretionary bonus, some type of objective bonus where they work this many hours, they're entitled to this much more money, or they hit this sales quota, they're entitled to this much more money. So those kind of non-discretionary bonuses, piece rates, like I talked about earlier, where they get paid based on how they perform, commission agreements. If sometimes commission agreements will make someone non-exempt, but if they're, exempt, but if they're still non-exempt, all these things factor into their rate of pay, where you have to take their hourly rate plus those things to figure out their total compensation during a pay period, divided by the amount of regular time hours they worked, and use that hourly rate to compensate for overtime purposes and the like. Well, now that's what you have to pay for meal break purposes as well. So if someone makes $15 an hour, but when you factor in their bonus, they made $20 an hour during that pay period, then any missed meal break needs to be paid at $20 an hour, not $15 an hour. Okay, that's an area where a lot of people make mistakes. So make sure you're getting that right. Don't interrupt meals. If they choose to stay on the premises and they're sitting, in the break room eating, don't call them within that 30 minutes, call them back in and ask them to help with something. If they did leave, don't make a phone call and ask for their help with something, or you're interrupting that 30-minute meal period and you're not compliant. I already talked about making sure they start before the end of the 5th hour. Some more wage and hour obligations. If supervisors are the ones responsible for calculating wages, they need to know all of these laws. Some of this I've already hit upon, but on call, if an employee is on call, that time may need to be compensated. If an employee, I talked about split shift, how that works, if an employee needs to be compensated. Travel time. Travel time is time if they're subject to the employer control, you need to pay them for travel time. You might pay them at a lower rate. Some businesses will pay, say, just minimum wage for travel time or something, but that's time they have to be paid for. Donning and doffing, if they have to actually put on certain equipment to do the job, There are scenarios where they do or do not have to be paid for that. I talked about objective versus discretionary bonuses and how objective bonuses factor into the rate of pay. Discretionary bonuses, where it's just, you did a good job, we're going to throw this much extra pay at you. That doesn't factor into it. But these are all things employers need to know. Overtime obligations, when are those triggered? If they work more than 8 hours a day, they're in overtime territory. If their weekly hours exceed 40 regular time hours, now they're in overtime territory. If they have to work more than 12 hours a day, the overtime goes into double time. If they work 7 days in a row in the same pay period, that seventh day is all overtime time and a half. After 8 hours, that day becomes double time. So there's all these overtime obligations. Supervisors need to know that stuff. They're the ones that are telling employees when to start and stop working. They're the ones that make a decision whether to authorize overtime and all of that. Withholdings from wages, payday requirements, and final check requirements. Withholdings are usually, most likely you're going to have a system set up on what you're withholding from a paycheck. So supervisors aren't going to have to monitor that too closely, but what they do need to know is what you can't withhold. So if an employee breaks equipment or was given equipment and didn't return it, a laptop, and they didn't return it, and you want to withhold that from their pay, supervisors need to know the law around that, because there are restrictions. You can't exercise self-help and withhold from their pay. You still got to pay employees, even if you think they owe you something back. When they need to be paid, there are very specific requirements on when employees must be paid by. If supervisors are the ones doling out paychecks, they need to know that law. If you're paying twice a month, the rules are between the 1st and the 15th. That has to be paid by the 26th, work performed between the 1st and the 15th. The second half of the pay period, 16th to the end of the month, that needs to be paid by the 10th of the following month. If you're paying in a different way from that, if you're paying, say, weekly or bi-weekly instead of twice a month, then you got to pay it within 7 days at the end of the pay period. So supervisors need to know that. Final paycheck requirements. Unless somebody quits without notice, they always have to get their final pay on their last day worked. You can't wait till the regular payday. If you're either firing someone or they gave 2 weeks, it's their last day, whatever it may be. If they give at least 72 hours notice, they get paid on their last day. If they quit without notice, you have 3 days to pay them. But supervisors need to know all that, because if you miss those deadlines, there are waiting time penalties that could end up costing businesses tens of thousands of dollars by not timely paying someone money they're owed. Be stuck on this slide. Give me 1 sec. There we go. Now I'm going to turn it back to Beth for disabilities and leaves of absence.
Okay, everybody, we have 3 minutes left in our webinar. We're likely going to go over a little bit to try and get through the slides, and we apologize. Again, this is a grab bag. Maybe we've gone into a little too much detail. So this section, essentially, these are the big laws that most HR and hopefully supervisors recognize when they hear. These are the big areas of leave statutes and reasonable accommodation statutes. But really what I think is important is that supervisors need to know there are lots of other statutory leave entitlements that employees may be entitled to. The ones that are listed here are under California law, and whether or not they apply to your workplace will depend on how many employees you have. But what we see sometimes in lawsuits, or at least even pre-lawsuits disputes, is that the supervisor will have an employee come to them and say, I need to go and attend this event at my child's school. And the supervisors only focus on, does this employee have any vacation available or any sick leave available? And they'll say, no, you don't have any time available. You can't take it off. Or no, it's too important right now at work and you can't have that time off. And they don't realize that what the employee is asking for may actually be a protected leave that they're entitled to. For example, the school activities leave. It doesn't mean that they shouldn't have to try and schedule things with the employer, but they may be asking for time off that they are in fact entitled to under a particular statute. So here are ones that are just not in the top tier. They're not FMLA, pregnancy, disability, or a leave for an accommodation. Those leaves or accommodations employers, including supervisors, are usually pretty aware of, but they need to know there are lots of other different statutory leaves. So that is what that slide gives you. And the other thing is that if an employee is entitled to a leave under a particular statute, the supervisor has to provide that leave, even if it may interfere with operations in that supervisor's department. Now, I hope, again, that most supervisors are not charged with having to administer this on their own, and that they work with HR whenever possible with respect to, one, analyzing whether the employee is eligible for leave, and two, then administering the leave appropriate. But if a supervisor interferes or denies a leave, it can place the employer at risk of liability. Reasonable accommodations. Here's what I want to say. I think frontline supervisors should never be charged with the interactive process reasonable accommodation analysis on their own. It is such a difficult process. It's very fact specific. There are many legal obligations that must be followed during the interactive process. We have to be careful that we don't step on our own toes by asking too much of an employee with respect to private medical information. We can't play doctor and make a decision that we don't think whatever the employee has told us they're facing qualifies as a disability or medical condition. This is a landmine, this area of law, that I think is very difficult. It's very difficult for highly trained and experienced HR professionals to deal with, let alone frontline supervisors who are not HR. So, the key for supervisors is that they should cooperate in the interactive process and reasonable accommodation analysis with upper management and HR, and the focus should be on the employee's work restrictions and those work restrictions in relation to what the essential functions of the employee's job are. And that's really the analysis to determine whether an accommodation can be provided, and if so, can it be provided without it creating an undue hardship for the company. One other area that we see in problems with supervisors is that if an employee is out on some leave and all of a sudden at the end of that leave they can't come back, the supervisor terminates their employment and says, well, we gave you 12 weeks of FMLA leave or CFRA leave and you didn't come back, so you're terminated. The problem is we have multiple statutes that often overlap and work together. And so it could very well be that although we satisfied the obligation under FMLA and CFRA and gave them that leave, if they can't come back because they're still suffering from a medical condition or disability, we may now be in ADA and FEHA accommodation land, and the supervisor needs to know that that employee still could be protected, and we may have to provide leave as a reasonable accommodation. So again, this is a dangerous area. We've seen cases in this area, and supervisors should work with HR. Okay, we are now done with the substantive areas of law. Lukas and I probably went into too much detail on those areas rather than just kind of telling you to be sure supervisors are aware of certain hot topics. Really now, the last part of the webinar, and I don't think we'll get through it all, but you'll have it in your materials, is how important it is to have effective contemporaneous documentation. Lawyers always say document, document, document. Right? Document, document, document. But what does that mean? And I will tell you, I will say the one time that I won't say document, document is I would rather you have no documentation than bad documentation. So when we say document, 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 we want to make sure your documentation is good and helpful in case there is a claim. It can minimize, it's great for morale and performance, but it can minimize liability. And what you want to do is you want to make sure you document certain things that if they become the issue in later litigation, we have contemporaneous documentation that really captures what happened at the time. So performance and attendance issues, performance evaluations and counseling, discussions and requests for accommodations or leaves of absence, investigations into misconduct or policy violations, disciplinary actions, and terminations. It is so much better to have a contemporaneous document that is good and is accurate based on, you know, what happened at the time, than years later in litigation for the supervisor to have to be trying to remember why something happened, why they took an action, and so forth. You know, plaintiff's counsel will argue in litigation, if it's not documented, it didn't happen, right? So it's a he said situation, or she said situation. So you want to document. When you're preparing the document, the supervisor needs to know who's the audience. Well, it's the personnel file, so we have a good record, but it is also the judge or jury in the later litigation, or even plaintiff's counsel when evaluating whether there's legitimacy and merit to a potential claim. So we want the documentation to be effective, and we want to think about who may be reading it in the future, and why is it important that it be effective and clear and objective. So let's, we're going to skip these slides because you can read those, but I want to get to characterizations or characteristics of good documentation. Timely, because it's fresh in your head. Limited to relevant performance issues or behavior violations, or whatever the issue that you're writing about is. You should include specific names, dates, times, places, have objective relevant facts, not assumptions, not opinions. It should be accurate, obviously. It should be complete, include a corrective statement of the steps to be taken, not just the infractions that occurred. Free of hearsays and innuendos and suppositions, free of inferences to protected characteristics or activity, and free of emotion and subjective opinion. Okay, I once had a case, we had to get it settled pretty quickly, where, you know, in addition to documenting the policy violation by the employee, the supervisor included a little note, she must have been off her meds today. Well, that kind of commentary should never be on a personnel record. So what's an effective discipline memo? Explain who, what, where, when, how. What is the purpose of the memo? Why am I writing it? What happened? What's going on? Okay, those are facts. Who, what, where, when, how. A reference to any prior discipline or previous opportunities to improve. A reference to relevant policies that may be implicated by whatever the issue is, the misconduct is. A statement of the employer's expectations for improvement and compliance. A statement of the consequences if the employee fails to improve or comply. Documentation should be legible and show who wrote it and the date it was provided. Now that sounds very elementary, like, Beth, do you really even have to say that? But if we're defending a lawsuit years from now and we're looking at documentation in the personnel file and there's a disciplinary memo, but it doesn't show who wrote it, it doesn't have a date, and it's hard to read, it's very hard for the employer to rely on that memo in defense of the lawsuit. It's very hard for employment counsel, when we're defending the employer, to know who do we talk to about this memo, who wrote it, who can authenticate the memo and testify about it. So it must be legible so you can read it. It should identify who wrote it, and it should have the date that it was written and provided to the employee. And then always provide a space for the employee to respond if they wish, they don't have to, and a signature line where they're acknowledging receipt of the memo. Okay, Lucas, it's back to you. We are at 11:38.
Okay, thanks, Beth. And I will get us through these last few very quickly. Effective performance evaluations. This is your performance evaluation. What I would say, number one, be honest in your performance evaluation. There can be a tendency for sometimes for supervisors to hold back, to sugarcoat. You know, if there are performance issues, or or behavioral issues, they need to be documented in there. One of the common things we see in lawsuits that becomes very important is the timeline of when performance or behavioral or disciplinary issues begin to manifest versus when an employee might engage in some type of protected activity. So you really need to, again, this is your evidence. You're writing a record to a judge or jury, essentially, if the business ever gets sued. It's very important to have, accurate performance evaluations when you're writing it. And remember, you're evaluating the performance, not the employee. So it should rely on objective facts and not just your opinions, the supervisor's opinions. You should be able to point to actual incidents and issues and talk about what happened and how it can be done better, et cetera. Obviously, never, ever use an employee's protected class or activity as a basis for any performance review. Supervisors need to wear that. The rest of the stuff you could read, so I'll just move forward quickly. A couple of illustrative examples that help you figure out what's a good versus a bad performance review. So that first one, Art is a good worker, but has to improve his communication skills. Here's what we've discussed that he can improve. That's a good one. That's how a performance evaluation should be done. The second one, I have had to coach Ashley on repeated occasions. I feel sorry for her because she was probably just frustrated about being the only woman in an all-male department. Now you're getting into protected class issues. You're making assumptions. You're bringing your own opinions into it. That's not how you want to conduct a performance evaluation. Some more examples. I'll just do one more, the top one. I like Jeremiah. He's been around so long that he got experience in everything. He has experience in everything we do. However, he is slowing down, so I am cutting back his goals next year and will recommend to him that he retire at the end of next year. Not ideal. That's starting to, he's slowing down. Is that an age issue? Is that a disability issue? There's no reason to be getting into that or recommending that he retire at the end of the next year. If there are actual performance issues, things you can point to, concrete things that are evidence of of slowing down and not doing the job correctly, point those out. Don't get into all this other stuff and recommending he's going to retire. Not contemporaneously documenting, again, you can read this one. This is sort of a rehash of what I was just already talking about. So in the interest of time, I'll move on. Overzealous documentation, notwithstanding everything Beth said, which I completely agree with about document. You want to be careful that you're not seen as overly papering the file to create a record. And the way you evaluate that to make sure you're not overzealous is look at how you're documenting other employees with similar issues. Is everyone else getting a 2-line evaluation and this person's got 3.5 pages? That kind of thing. Emails, and in addition to emails, I'll add to this one, text messages. Anything that's in writing needs to be viewed through the prism that it's part of an evidentiary record if there's ever a lawsuit. So you always have to be careful what you put in an email. If you're not copying an attorney on it, it's probably something that's going to be discovered in a lawsuit. So make sure that whatever you're saying about an employee, if you're putting it in writing, make sure it withstands all the scrutiny on all the things we've just been talking about. So it's not just the official performance evaluation, but informal things like text and emails as well. There are specific places where you have to keep certain documentation. Any disciplinary stuff about the employee has to be in their personnel file that is maintained in a specific place. Any grievance they raise, anything, any complaint about them, anything about their performance has to go in that personnel file, which employers have an obligation to keep for 3 years and provide to employees, et cetera. So they need to be aware of that. Medical documentation, for any reason, whether it's a workers' comp issue, a leave of absence or disability accommodation issue, if you have any medical record of that employee in this COVID vaccine, all of this stuff that's been coming up lately, that's kept separate and apart from the personnel file, and it must be kept confidential. Supervisors need to know that as well. Their own notes. Again, I talked about texts already, or if they write anything down about the employee's performance, they cannot keep their own separate file. That all goes into the personnel file. And with that, I think that brings us to the finish line. So I'm sorry we ran a little bit over there, but I hope this was valuable. A couple more things I just want to point out while we're still here is we've got a couple of, well, we didn't get enough time to get to questions today, but you have Beth and my contact information if you want to reach out about anything. And then upcoming, I think the last couple slides, which you'll get a copy of, show our next couple webinars. We've got one. Next one is on September 1. It'll be on the employment life cycle, EEO compliance from hiring to firing. So a little bit more depth on some of the stuff we hit at the beginning of this one that supervisors need to know. And then on October 6th, we'll be doing avoiding the bully pulpit, best practices for creating an inclusive workplace free of bullying and intimidation. Another valuable one for those who are able to make it. And with that, I think that will end our presentation today.
Thank you, everyone, for joining us. Sorry we went over.
Bye, everyone.
Bye.